It's well known that some children of divorce are downright devastated when their parents part ways, while others experience relatively few issues. Certainly, this broad range of impact is in part attributable to the gamut of parenting approaches that can follow a split. In the Connecticut case of Nicita versus Kittredge, we examined the court's treatment of a post-divorce parenting plan turned disastrous. Peter, Nicita and Allison Kittredge were married with 2 children, Alec and Madison. Although their marriage had been performed by a priest and rabbi, and the family celebrated Christmas and Hanukkah, they hadn't committed to raising their children in either faith. In 2001, the couple divorced and agreed upon a parenting plan that provided joint legal custody. The agreement stipulated in part that the children's primary residence was with Allison, who was to make day-to-day child care decisions. Major decisions, however, were to be taken after discussion and agreement by both parents. The agreement also prohibited the parents from exercising their respective powers to frustrate, deny, or control the other's lifestyle. The plan also required Peter and Allison to work together cooperatively, amicably resolving disputes, all in the best interests of the children. The co-parenting that ensued, however, was no less than a cataclysmic mess. Both parents' conduct ran wildly afoul of the cooperation necessitated by the plan. Peter and Allison both took action to undermine the other. Allison moved to another town without telling Peter and unilaterally made decisions about the children's activities and schedules. She also decided the children were to be raised in her Jewish faith and started having Alec attend Hebrew school. When she did seek Peter's input, he was actively resistant and untimely with his responses. He spoke ill of and derogatorily to Allison in front of the children. He also hired 4 separate private investigators to dig up evidence substantiating his allegations of Allison's alcohol abuse, to no avail. Contact between the parents was consistently acrimonious, even in front of the children, who had suffered in every way, including religious identity confusion and anxiety. In the 3 years since Peter and Allison agreed to the plan, at least 2 guardians ad litem were appointed for the children, with one resigning after being threatened. 75 post-judgment motions were filed, and some modifications were made to the parenting plan. Nonetheless, the plan clearly wasn't working and was detrimentally affecting the health and well-being of the children. Peter petitioned the trial court to modify the parenting plan. During a hearing lasting several days, the court reviewed exhibits and heard regular and expert witness testimony.